rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV140176, Foster versus the Town of Quartzsite et al. Counsel, we are recording today's proceedings, so when you step to the podium, if you would please identify yourself and the party or parties you represent. Each side will have 20 minutes for argument, and appellant's counsel is responsible for watching the clock and reserving any time for rebuttal that you might desire. We've read the briefs and we have conferenced the case prior to this argument. So with those preliminaries out of the way, counsel for the appellant, you may proceed.
Okay, would you like me to stand at the podium?
Yes, please.
Good morning, judges. It is an honor to be here before you today, in particular, because this is such a unique and fascinating issue that revolves around the meaning of the word approve, and also involves the people's power of referendum, which goes back to the Arizona Constitution, and yet this is an issue of first impression. My name is Julie Lebenz, and I represent Quartzsite Mayor Edward Foster, who's here present in the courtroom today. Now, this case arose out of a dispute between Mayor Foster and the Quartzsite Town Council, in which the mayor interprets the final words found in ARS 19-142B to give him a discretionary approval power in relation to emergency ordinances. And the town council disagrees and says that the mayor does not have any sort of discretionary approval power, and that instead it is merely a ministerial act of signing his name as to what had transpired. So rather than an approval, it's more of a witnessing and a signature, according to the town council. Now, as this dispute unfolded, the mayor sought an injunction to prohibit the town council from acting on what he determined to be an inoperable emergency measure. And the lower court judge ended up dismissing our complaint for failure to state a claim. And that's resulted in today's appeal. This case, at the heart of it, involves an issue of statutory interpretation. And as this court is well familiar, statutory interpretation starts with looking at the plain meaning of the words used. And given that this court is here to determine whether or not the lower court case should have been dismissed, and in other words, to find out whether or not the mayor did in fact state a claim, this court merely needs to find that any theory of law supports the mayor's case, and in that event can find that the dismissal was not proper. With the plain meaning, we first look to the language itself. By looking to the language itself, we are specifically determining what the words "and also approved by the mayor" mean. And in particular, that word "approved." Now, the plain meaning of approved is much more than a ministerial act. And I know that Judge Thuma, you in fact wrote a law review article a few years ago talking about the use of dictionary definitions in U.S. Supreme Court cases, and had concluded that there needs to be some guidance in how the dictionary definitions are used. And I did in fact use a dictionary definition in this case of the word approve, in that the dictionary defines it as to like. And to like implies and embodies a discretionary act.
Can I ask you there?
Yes.
That is one meaning of approved. Is that fair?
Yes, there
But
were
not-
more than one
Right.
definition. That was, I believe, the first definition used in the Webster's New World Dictionary. If this court finds that the plain meaning is clear and unambiguous, and that it does not result in an absurd outcome, the inquiry stops there. We need not go any further and look outside the plain language itself, and this court can make a conclusion there. And we do urge the court to move in that direction to find that the plain meaning is clear and unambiguous and does not lead to an absurd result, because the plain meaning of approve involves not only just signing off, but having an opinion as to whether something is proper or not. So having discretion in reaching a conclusion. However, I would like to talk about some aspects beyond just the plain meaning in the event the court wants to look at the statutory scheme, the statute itself, comparisons to the Constitution, which has nearly similar language but some very distinct differences that support Mayor Foster's case. So let's move outside the plain meaning, although first and foremost I do want to make clear that our case is that the plain meaning is clear, that approve is a discretionary act, and that the court can find that the plain meaning, that legal theory supports Mayor Foster's case, and can then remand the case back to the lower court. If we look outside of the plain meaning and we look at the statute itself, we find that the statute is found within Title 19, which applies to initiative and referendum, in particular at the municipal level. In 19-142B, we see the direct application of those constitutional powers that are reserved to the people. And it is explained in that statute the procedure to follow and distinguishes between passing a non-emergency ordinance and an emergency ordinance. What is so key here is that an emergency ordinance is not subject to the people's referendum power and goes into effect immediately. It's immediately operable, so long as three requirements are met. Number one, a statement of emergency. Now here we have the statement of emergency being the need to secure an interest rate. And yes, I concede that this is not the province of the court to analyze what was used as the emergency to justify moving forward under an emergency ordinance. However, the facts of the case are relevant. And the facts here show that this ordinance was originally passed as a non-emergency ordinance. A member of the audience stood up, yelled out referendum, and in fact organized a political action committee and obtained a sufficient number of signatures on a referendum petition and submitted that to the clerk.
Counsel, how does that help us answer what also approved by the mayor in the statute means?
That helps us because what we see here is a rush by the town council to use the emergency ordinance provision in order to circumvent the people's right to a referendum petition.
That's not your challenge. That's not your client's challenge here. Your client's challenge is the effective date of the emergency ordinance.
Judge,
and I don't know that at least appellees make a fairly compelling argument that whether this is properly an emergency ordinance or not is really beyond the province of this court, that's a political question.
Correct. But how these facts relate and what the mayor's case is that he is seeking to uphold the people's constitutional referendum power. And he was well aware that the people sought to submit a referendum petition and to put this to the voters.
But isn't the purpose for the filing of the litigation for what we're asked to decide, which is a narrow question of, important question, but a narrow question of interpreting an Arizona revised statutory provision. The purpose of your client pressing this cause is comparatively irrelevant to that decision. Wouldn't you agree?
Well, it's not irrelevant to Mayor Foster, and I know that is important to him.
From the court's perspective.
Yes. In fact, the court here is to determine those final words of 19-142B.
And in fact, and the parties briefed this, but the court cite ordinances and town council procedural policy and other provisions dealing with the allocation of powers between the council and the mayor. We're not asked to decide that either, are we? It's a narrow statutory issue.
It's a narrow statutory issue, that's correct, regarding what it means to be also approved by the mayor. Is that simply signing off, or is that a discretionary act where the mayor can approve or disapprove? So yes, I do agree with you on those points, and simply wanted to give a little background for context, but I'll move forward. Under 19140B, in order for an emergency ordinance to move forward, there has to be the statement of emergency, 3/4 vote of the council, and then also approved by the mayor. It's undisputed here that the first two prongs were fulfilled, and we're left with that final prong regarding the mayor's approval and what that means. Now, we know that the court is tasked with giving meaning to every word in the statute, and that is part of interpreting the statute. And unless there's an absurd result, then that plain meaning should be followed through with and fulfilled. And what we see here is that there is no absurd result. In fact, we see that under 19-141, it states that the mayor and the governor should have as similar roles as possible in the context of emergency and non-emergency legislation. And that brings us to the constitutional provision under Article 4, Part 1. So we see already, based on 19-141, that there is a position that the mayor and the governor are supposed to be as similar as possible. And also the procedure at the state level and the municipal level is supposed to be as similar as possible. But the key distinctions here between the Constitution and 19142B support the mayor's case. We see that in the Constitution, it is written so that a legislation, emergency legislation, will be passed if it's approved by the governor or if it's passed over his veto. Whereas in the statute talks about when the ordinance becomes immediately operative. The mayor doesn't have the same power as the governor as far as being able to determine whether or not the ordinance passes. His power relates to the timing that it becomes operative. And that takes us to the referendum power of the people. By the mayor being able to have a say as to whether or not a proposed emergency ordinance is immediately operative, gives him the role in allowing the people to exercise a referendum power. And the mayor in this case knew that the people wanted to do that. It was clear, everybody knew it. And so his objection, his disapproval of the proposed emergency ordinance was him acting to fulfill the constitutional right of the people. I am going to...
The act of writing veto had no legal effect.
Excuse me?
The act of writing veto had no legal effect under the statute. It was the withholding of approval under your theory that had the legal effect.
That is correct. That is correct. I am going to reserve 5 minutes for rebuttal, so I'll go on for 3 more minutes. In addition to, in continuing on with this comparison between the Constitution and the statute, we see the past versus the immediate operation, and we also see a key distinction at the very end of each provision. We see that under the Constitution, when the governor vetoes, the legislature has a 3/4 vote, they can override the veto. The governor's approval does not come into play after that time. But we see in the statute, there's the 3/4 vote and also approved by the mayor. There's a distinction there. And what I am asking this court to find is that that distinction is key in that those words are not meaningless. Those words were put there for a reason, and those words were put there to give the mayor discretionary approval power in order to be that safety valve to protect the people's right to a referendum. Now, this does not result in an absurd result, or does not lead to an absurd result, because we see in Clark v. Boyce that the court instructed that emergency legislation should follow the same, if not a very similar path as non-emergency legislation. When the mayor did not approve of the emergency ordinance, it simply kicked it back to being just like a regular ordinance, in that it was subject to the 30-day referendum period. Now, at the legislature, not only do they have to wait until the legislative session ends and then 90 days for a referendum petition to be filed. It's much shorter. At the municipal level, it's only 30 days. And that could very well be the reason why the legislature put in the mayor's approval power after the 3/4 vote of the council, because the time period is so much shorter in that it's just a 30-day period for a referendum petition to be filed. Overall, we start with the plain meaning. If the plain meaning is clear and unambiguous, it does not lead to an absurd result. The plain meaning is followed. Here, the word approve, the plain meaning is much more than just a signature. If it was just a signature, that's what the statute would say, and also signed by the mayor, but it doesn't. It says approved. Numerous cases have been cited to her in the brief showing that approved is commonly defined as being much more than just signing off. With that, I'll turn it over to my colleague. Thank you.
Thank you.
May it please the court, I am Patricia Ronan from the law firm of Curtis, Goodwin, Sullivan, Udall, and Schwab. I'm accompanied by my colleagues Kelly Schwab and Trish Stuhan. We are here on behalf of appellees, the town of Quartzsite, the Quartzsite Town Council, the Quartzsite Town Clerk, and the Quartzsite Town Manager. Fundamentally, we seek to avoid an absurd result. An absurd result which would allow a mayor to absolutely veto an emergency measure approved by the vote of 6 of 7 members of the Town Council of Quartzsite on the 17th of December 2013. There's no dispute, as my esteemed colleague has said, that pursuant to Title 19-142B, 2 out of 3 of the elements necessary for bringing an immediately effective emergency measure took place. There was an emergency clause. More than 3/4 of the council approved the emergency measure. The issue is, did the mayor have to approve it, and what was the scope of the mayor's authority with regards to that? Title 19 is not a provision of the Arizona revised statutes that vests power or authority in a mayor. Instead, it establishes the procedures whereby resolutions and ordinances that are subject to referendum follow specific procedures in contrast to emergency measures that become immediately effective. And the governor's role is clarified in Clark v. Boyce with regards to what approval means for emergency measures from the state legislature, and that case guides us here. Clark v. Boyce is very clear that even when an emergency measure is passed, where the governor disagrees, where the governor's state of mind is not to like the emergency measure, and it is passed over the governor's veto, which is expressly provided for in the Arizona Constitution, the governor does not have an absolute veto. That emergency measure can go back to the Arizona state legislature, and the state legislature, by 3/4 vote, the very vote that is necessary of the Quartzsite Town Council, can still pass the emergency measure, and without the governor's signature or approval can become immediately effective. And that is the case for Quartzsite. The statute tracks the Constitution, except the difference is there is no veto allowed of an emergency measure for a municipality, and instead it's much more efficient. The mayor contends that he is defending the right of the voters. In fact, he is interfering with the right of the voters because he has taken an absolute veto power for himself, or instead claimed a line item veto for which there is no precedent. The idea that a mayor could rewrite by excising an emergency clause from a duly passed measure by council is novel. There is no power in town code, in state constitution, or in Arizona revised statutes that grants that to the mayor. And put simply, the mayor has no power that is not expressly written in one of those three places.
Counsel, let me ask. It seems, and I know the briefs argue about other sources and issues, including local law, that is unique to Quartzsite, sort of by definition. But we're asked, I think, to decide a very narrow issue applying Arizona revised statutes on the effective date of an emergency resolution. Do you agree with that sort of recitation? There are a lot of other things swirling around, but it really is the effective date.
Yes,
correct?
Your Honor.
Okay. I wanted to make sure, because I understand from the briefs, and you have done both a nice job of giving us some good, helpful context on what sort of the balance of power in the town of Quartzsite. But that's not really an issue we need to address or decide, is it?
Your Honor, if you accept the interpretation of approved as presented by appellant, it results in an absurd result, and it is, in that sense, the issue that you need to decide.
Help me understand that.
Okay. If the mayor is able to not approve, if it is a discretionary power, the emergency measure does not go immediately into effect. And in fact, the emergency measure never goes into effect.
Why is that?
Because if the mayor is the only one who can approve, and that is taken to that literal meaning, and if the town code's provisions, which we believe are valid, which allow someone other than the mayor to sign, are instead invalid, and only the mayor can approve or disapprove, and the mayor has a discretionary right, then he does have an absolute veto.
Well, but let me ask, because with respect to what the ordinance allows, clearly the Quartzsite town law cannot trump statute. Do you agree?
Yes, sir.
Okay, I'm glad.
There would be a case on that, I think, the Ponderosa.
Ponderosa, a
case,
case that Judge Gould had a hand in. So,
teasing him. He cited it, so I wanted to say it today.
but doesn't it seems to me that 19142B talks about the effective date of either an emergency ordinance, which is and I'm using a shorthand because it's more than just ordinances, ordinance, resolution, or franchise, and that's in the last sentence of that provision, or the effective date of what you could call non-emergency, although that's not the term that the statute uses. Do you agree? I'm seeing your head nod up and down. Do you agree with that
Yes,
sort
Your
of
Honor.
proposition? And so the question, I think, that 19142B addresses is not whether an ordinance or a resolution is effective, it's the date upon which it's effective.
I agree with you 100%, and that is why the 142B is a procedural statute and not a grant of power to the mayor. That is why approve is a ministerial power, not a discretionary power.
Let me ask you about that, because approved by the mayor is used the very last clause of the emergency provision, but then a really similar provision, approval by the mayor, is used for the non-emergency provision, and that clearly, I think, contemplates a qualitative assessment by the mayor.
Your Honor, respectfully, I disagree with that interpretation.
Okay.
I believe that in both cases it is a ministerial duty, and approval means the same thing in both cases. In the first, however, because it's the first clause discusses resolutions and ordinances which could be subject to referendum.
Although
the issue
that issue is addressed in some other subsection or section.
Correct,
Right.
but the effective date, if it's subject to a referendum, is 30 days out. The date of approval is when the 30 days begins to run. So when the mayor signs it, that's when the 30 days begins to run, and that's clarified by 19142C. In fact, in the second sentence of 191.
Go ahead.
In the second sentence, it says, if the copy of the ordinance or resolution proposed as a referendum is not available to the person, referring to a person who wants a copy of it to make a petition at the time of making the application for an official number for a petition, or on the same business day as the application is submitted, the 30-day period prescribed in subsection A of this section begins on the day the ordinance or resolution is available from the city or town clerk, and the ordinance shall not become operative until 30 days after the ordinance or resolution is available. So it's not going to be available until it's been approved by the mayor or the individual charged with that duty in the town in the event of the mayor's absence.
Well, and just by sort of reading on in the first sentence of 19142B, it appears to contemplate if it is not approved by the mayor, and it talks about passed over the mayor's veto in that portion only. It talks about certification by the clerk, right? Which I assumed, just by context, that was a proxy for the lack of a signature by the mayor if the mayor didn't approve it.
If I may, Your Honor, I believe that there are two processes in finalizing an ordinance. There's a draft ordinance that's made public in the notice of a public meeting, and it's presented to council and the public. Then council will discuss in the town council meeting and may revise the text of the proposed ordinance. The clerk will then revise that, and it must be reviewed to be correct. That's the essence of the mayor's task, is making sure that the ordinance as presented after the conclusion of the vote by council is correct and accurately and adequately reflects the decision made by council. So the duty of the mayor as the chief executive officer of the town is to make sure that, much like the presiding officer in the state senate or the House of Representatives in the legislature, is to make sure that the ordinance as presented is correct. And that's the nature of the approval.
What is the certification? How does that differ then from certification by the clerk?
Ordinances are typically signed by both the mayor or executive officer of a municipality, the town attorney, and the clerk. So all three will typically sign them. And so the clerk will certify the official copy.
So the way you read the first sentence of 19142B is even when the mayor vetoes, and let's set aside for a minute a mayor's power to veto, because that's not an issue we're asked to address. But even when that happens for a non-emergency provision, that approval by the mayor that appears right before, unless it is passed over the mayor's veto, still applies? That the mayor still has to approve something that the mayor has vetoed?
Yes. And that's
Case law supporting that?
I believe that it's provided for and discussed at length in Clark v. Boyce.
Well, but
And
that didn't address this statutory scheme.
It doesn't address the statutory scheme, and in fact, there is no case that specifically addresses the statutory scheme.
And in
However,
fact, Oregon had this statutory scheme for a period of time, and no cases under Oregon law did that either.
The case, City of Tucson versus Arizona Mortuary, is very helpful. In that case, granted, Tucson is a charter city, and this is a case from 1928, and I actually believe that these issues were dealt with very early in our state's history, and that's why they haven't arisen again. It's because, to some extent, I think our early officers and leaders felt that there was some clarity, and now we're struggling again with the statutory interpretation. But the court in that case noted that there were no provisions for veto in the Tucson City Charter, but there was a provision if the mayor failed to approve. And it said, in the absence of any special provision requiring such action, an ordinance after the mayor failed to approve it need not be returned for reconsideration or repassage if it's received the votes of 5 members of the council on its original passage. In such case, it is valid without any further action, regardless of whether or not the mayor has approved it.
But which way does that cut? I mean, if we're to apply this, doesn't that suggest that approval by the mayor under the first sentence of this statutory provision, that if the mayor doesn't approve it, the mayor's work is through. It's done. The mayor doesn't then sign it. It's certified by the clerk if the failure to approve it is overridden, and the statute uses the term veto, but I understand it's a hot button term. So under the case you cited, Wouldn't that be consistent with the fact that approval by the mayor really is a qualitative assessment? And if the mayor doesn't approve it, the mayor doesn't need to affix a signature to that provision.
If the mayor does not approve it, the mayor does not need to affix a signature. However, I still contend that it is a ministerial duty, because under the course of facts given, which is that the ordinance or the emergency measure was properly embodied in the ordinance or the measure as written and recorded, he had one course of action, which was to sign it, to approve it. And that is the definition of ministerial duties as presented in Con v. Thompson, 185 Arizona 408, which cited State Board of Barber Examiners versus Walker, a 1948 case. And recognizing that approve is a ministerial duty in cases such as this, not this statute, where one branch of government, and we're thinking of the mayor in the context of him as approving, not acting as a member of the council or the legislative body of the town, but instead as the executive officer of the town, as checking the work of the legislative branch, making sure that it's appropriate. Not checking it in that, is it really an emergency? Not doing that work because he doesn't have that authority granted to him, but instead making sure that it's correct and the proper procedures have been followed. That's what happens in Birdsall versus Pima County, Mann versus Maricopa County, Royalston versus Pima County. In all of those cases, branches of government, typically the judiciary, has a power granted to it to hire and fire people, set salaries, and the branch that's checking them simply makes sure that there is no abuse of power, no arbitrary and capricious behavior, and if there is none, then they have an obligation to approve. And that's how those statutes are interpreted.
And let me set aside for a moment, because I struggle in that concept with the arbitrary and capricious. That seems, you're headed down a qualitative path when you get there. But you would agree, wouldn't you, that those cases, and the parties, I think, have done an admirable job of arguing by analogy, but those cases are by analogy. They don't apply this same provision. Is that correct?
That's correct.
Okay.
Fundamentally, the mayor's task is to approve the emergency ordinance. Fundamentally, the emergency ordinance must go into effect immediately. And because the mayor was charged by the town code to immediately sign, and he did not do so, the town code allowed the vice mayor to sign. It is only because of this appeal that the ordinance has not been acted on. Bond counsel for the town has not been able to say that the subject has not been that the subject of the bond has not been the focus of litigation, and the improvements, the emergency of the town, which was to improve the wastewater treatment plant and expand it because it was at such capacity that no additional users could be added. That emergency has not been able to be dealt with. It's been almost a year. We ask that you find that no
Council, why not just go back? They had the votes. They had a supermajority. Just go back, pass it as a regular measure, and certify the minutes, and 30 days later it goes into effect.
It's the council's discretion, Your Honor.
But
Certainly it's been more than 30 days now in this case.
There are two reasons. One is that council cannot bring a measure back for more than, unless 6 months have passed, and parties have been involved in settlement negotiations, so council did not do so.
Council, let me ask you about that. The emergency measure that has brought this appeal was enacted a week after a non-emergency measure on the same topic was enacted. Is that correct?
That is correct.
So I didn't understand the 6 month.
Because based on the if there's an interpretation that there was no basically the 6 months is council can't deal with the same subject within 6 months. If there is an understanding that it wasn't passed, if we understand that the mayor didn't approve it and we take that to be binding and that's justification for acting again, there would be a 6 month bar. But the town's position has consistently been that it should be immediately effective, and so further action was not appropriate or necessary.
Oh, and I understand that position, but by middle January, the December 7, if I recall, non-emergency resolution would have become effective. Is that correct?
The non-emergency resolution was withdrawn by council upon the passage of the emergency resolution.
All right, thank you. And I think you had a second point that I interrupted you before you got to, in response to Judge Gould's question.
Actually, I'm the one who interrupted you,
Oops.
so I cut off your point. Did you want to talk about the Ponderosa case at all? I'm teasing you.
If you'd like me to, I would be happy to. Fundamentally, municipalities are governed by the council, and the mayor's conduct in this case does not state a claim which should be upheld. He does not have a power in any law. The procedures of 19142B are that this emergency statute should go into effect immediately. The mayor has taken 2 bites at the apple. He voted against it, and he is trying to vote against it again and absolutely veto it. His novel claim in his appellate brief that he has a line item veto, which gives him the authority to excise the emergency clause and subject it to a referendum, which was never brought before, for which there was no petition ever submitted, is unsupported. Instead,
Let me ask you, if we're asked to, and I think said it a couple times, to construe only 19142B, and more specifically the last sentence of that, we need not address veto powers, line item veto powers, things like that. Do you agree?
in the event that I agree that veto powers need not be assessed, except that the only way that approve can be understood to allow the mayor to disapprove, the result of that is to give him a veto power.
Well, that's one way of looking at it, but that's your claim that hasn't, your client's claim that's never been brought, fair? We're here on the mayor's claim about what 19142B means, not did the mayor, if also approved by the mayor has a qualitative component, there's sort of no cross-claim that this was contrary to city ordinance or town structure, correct?
That's correct.
And that may reflect the procedural nature of the case, a 12B6 motion.
It does, yes, Your Honor. So just as a summary, again, I urge you not to grant attorney's fees. I urge you to dismiss this case and affirm the action, or the holding below. Thank you.
Thank you, Ms. Ronan. And rebuttal, Ms. Lippens?
First, I'd like to point out that the appellees have misstated appellant's case in that they continually allege that Mayor Foster seeks to have a complete veto of the emergency ordinance. However, he doesn't have that power under the statute. We have to look at the language used in 19-142B, which doesn't say anything about passing. It talks about the time of operation, whether or not an emergency ordinance is immediately operable or not. Secondly, the appellees have claimed that the mayor's case results in an absurdity. However, I'm not sure where the absurdity comes into play here. Basically, what the mayor argues is that 19-142B gives him control over the timing of the approval. What's absurd about that? Now, with the Clark v. Boyce case, it clearly states in that case that no bill passed over the governor's veto is ever signed by the governor. And this court asked many questions about the signing by the mayor and things of that nature. But what we see here is that with the 3/4 approval in the emergency context, we then have the mayor's approval. And so although a governor never signs a law passed over his veto, we have here 19-142B demanding the mayor's approval following a 3/4 vote of the council. And that again brings us to those key distinctions between the Constitution and the statute. Now, overall, we start with the plain meaning. I've made those arguments here. I am asking this court to follow the plain meaning, implement that, which is that approved has a discretionary element, or as Judge Thuma has said, a qualitative element to it. And we're also asking for an award of attorney's fees under the private attorney general doctrine. The mayor seeks to uphold the people's right to a referendum. And if this court rules in his favor, he will have vindicated that right and would be in a position for an award of attorney's fees under the private attorney general doctrine. Unless the court has any final questions for me, I am going to conclude. I thank you for this opportunity and look forward to reading your decision. Thank you.
Thank you. Thank you to both counsel for your arguments today. They were quite helpful. We will take this matter under advisement and issue a ruling in due course. At this time, the court stands adjourned. Thank you.